Coney Barrett, in the middle of the Supreme Court hearing room, wore her black robe sharply against the warm mahogany wood paneling that lined the nation's highest court. Moments earlier, Chief Justice John Roberts had locked gazes with her and declared, "Perhaps Justice Barrett, who has limited experience, may wish to recuse herself from this constitutional interpretation." A stunned hush fell over the room. Experienced court observers sat in stunned silence as Chief Justice John Roberts publicly scolded the court's newest member, something unprecedented in recent judicial history. Whatever would be said during the next 2 minutes would calm the courtroom and possibly change the internal dynamics of the Supreme Court for decades to come. In a mere few purposefully chosen words, Barrett was about to reverse Roberts' acidic rebuke into the most regrettable judicial misstep of his career. Before we bring you into this incredible story of courtroom clash, we urge you to subscribe to our channel and like this video for more in-depth reporting on America's most powerful institutions. These are the stories the mainstream media ignore. In order to understand the stakes here, it's worth knowing who these judicial heavyweights are and why their disagreement matters to all Americans. Chief Justice John Roberts, who was nominated in 2005 by President George W. Bush, has now served more than 15 years leading the court with a reputation for centrism and institutional stewardship. The Harvard-trained jurist with deep ties within the legal establishment has, in the last decade or so, joined liberal justices on important cases involving healthcare and immigration, frustrating conservatives who had anticipated a more reliably ideological course. Behind his serene public demeanor is a strategic legal mind, one determined to preserve what most see as the entrenched Washington orthodoxy. Justice Coney Barrett, by contrast, is a new generation of conservative thought. Nominated by President Trump in 2020 to succeed the late liberal legend Ruth Bader Ginsburg, Barrett had impeccable credentials: a one-time law professor at Notre Dame, a federal appeals court judge, a devout Catholic, and a mother of 7. Throughout her confirmation and subsequent tenure, she has been blasted by critics concerned that her Catholicism will contaminate her judicial ideology. But she has always approached her work with calmness, precision, and intellectual integrity. This confrontation with Roberts, however, was more than a demonstration against her qualifications. It was her moment to prove herself a strong voice on a court where seniority often amounts to authority. For millions of Americans who backed her nomination, this was a character test. The stakes were never higher. At stake was a constitutional interpretation with repercussions far beyond religious freedom. Having a sense of Barrett's growing sway over the court's conservative wing, Roberts determined now was the time to take on her dominance in the most publicized forum available. The entire legal establishment was observing, aware that this confrontation would have repercussions far beyond the marble halls of the Supreme Court. Tensions had been building since morning, when oral arguments had commenced in Fulton versus City of Philadelphia, a landmark case on religious liberties. Barrett's questioning revealed that she was formulating a new framework for assessing First Amendment claims, a one that risked overturning decades of constitutional understanding. Roberts, ever vigilant defender of the court's trajectory, appeared openly uneasy as Barrett's queries revealed a vast constitutional versatility that was stunning even to seasoned lawyers. The first flashpoint was when Barrett invoked a previously obscure 1887 precedent that challenged the interpretive approach Roberts had long advocated. "Justice Barrett," Roberts interrupted, his tone remarkably sour. "The court has gone much further than that old justification." Barrett smiled respectfully at his statement, but persisted with his questioning. In the press gallery, reporters exchanged glances, sensing a gap emerging between the chief and the new justice. As the hearing drew to a close, Justice Samuel Alito seconded Barrett's opinion, suggesting that her interpretation was a more textual if faithful one. Roberts's expression grew stern. It was clear other justices were already falling in a line behind Barrett. The real fight, however, was not waged in court but in secret at the justices' closed-door conference. When Barrett began explaining her position, Roberts interrupted her again. "We have worked on processes for interpreting these clauses," he curtly replied. Eyewitnesses remembered the unusually short-tempered tone later. This court has deliberately constructed these standards over decades. Barrett tried to interject, but Roberts continued to speak over her, an unprecedented and rude breach of the court's otherwise polite etiquette. Justice Clarence Thomas arched an eyebrow, but said nothing. The confrontation spilled onto public view later in the day. In another case discussion, Roberts spoke what appeared a calculated remark aimed squarely at Barrett. Perhaps Justice Barrett, who has limited experience, should recuse herself from this constitutional interpretation, he said. After all, these complex frameworks were established when she was still teaching law school basics. Gasps resonated in the courtroom. It was a stunning breach of protocol. Even Justice Sonia Sotomayor, although she had an ideological difference with Barrett, appeared plainly uncomfortable. Barrett was silent, her face unreadable, as Roberts continued, suggesting that she would have to be watched before being a full member of the court's deliberations. Justice Brett Kavanaugh glanced over at Barrett in concern. Justice Elena Kagan remained intent on her notes, suggesting that she was not going to respond to Roberts's very unusual remarks. As Roberts finished speaking, the courtroom fell silent. Everyone looked at Barrett. The solemnity of the moment spread with no reversibility. Standing tall, she realigned her papers, took a breath, and addressed the Chief Justice. Her voice, firm and unwavering, filled the room. "Thank you, Chief Justice Roberts, for your concern regarding my experience," she began, her voice respectful but unyielding. "I believe my decade-plus of teaching constitutional law has prepared me for this position, just as your background in private practice prepared you for your." The remark was a zinger, a reference to the fact that Roberts had no judicial experience prior to becoming Chief Justice, whereas Barrett had already had experience on the federal bench. She continued, "But I believe we can all be better served to read the actual words of the Constitution itself on this matter, and not simply utilize the models that have evolved over time." Digging into her stack of papers, Barrett pulled out a small, dog-eared copy of the Constitution, a go-to courtroom friend. Without referring to any notes, she cited 5 different constitutional provisions, weaving them together with lucidity and comprehension. "And perhaps most relevant to our discussion today," she continued, "is the historical understanding of the First Amendment's religious safeguards as explained by James Madison in his 1789 address to Congress." She then proceeded to read Madison's lengthy comment verbatim, a performance subsequently confirmed by legal scholars to have been precisely recited. "In light of those foundational texts," Barrett concluded, "I must respectfully disagree with the characterization that fidelity to original meaning betrays inexperience rather than judicial discipline." The room was silent. Justice Thomas nodded with evident approval. Even Justice Kagan looked up from her notes, her face reflecting a new respect. But Barrett wasn't finished yet. With a precision and devastating rebuke, she cited a 40-year-old law review article authored by no less than Roberts himself. There, he had himself advocated the very text-centered doctrine that she had just defended. As a young lawyer, Barrett quoted Roberts back, "You yourself wrote eloquently that the highest duty of the court is fidelity to the text above all institutional concerns. I have ever been a great admirer of that perspective and am only attempting to do justice to it throughout my service to this court and the Constitution." Justice Alito fought to stifle a grin. Roberts was speechless for the first time in his 6 years on the bench. The loquacious chief sat there, his boisterous confidence shaken to its core. A veteran court reporter later described it as the most elegant evisceration of a chief justice in modern history. Barrett had not raised her voice or shown indignation, but coolly, rationally, she had dissected Roberts' attack and established her intellectual dominance. And then Roberts finished. Finally, Roberts responded. "Thank you, Justice Barrett, for that excellent response," he said somberly. "The court will weigh all perspectives." Everybody there knew it, though. Under 3 minutes had Amy Coney Barrett gone from the court's newest justice to quite possibly its most influential constitutional mind. And she had accomplished it with tempered thinking rather than flashy eloquence. The aftershocks to the exchange were immediate. Legal blogs dissected each sentence of the exchange. The hashtag #BarrettBrilliance hashtag began trending across the country. Law students, academics, and pundits of all political stripes praised her performance as a masterclass in judicial calm. By evening, videos of the incident had been watched millions of times, with experts debating its place in history. Inside the Supreme Court, a mood shift occurred overnight. According to court sources, following the session, Justice Clarence Thomas went to Barrett in silence and commented, "That was long overdue." Typically reserved in temperament, Thomas was seen beaming as a smile as the two of them strolled out to their chambers. Justice Alito, who was taken aback, reportedly told a clerk that Barrett's response would be taught in law schools for centuries to come. Even Justice Storer, ideologically distant from Barrett, directed her clerks that the exchange underscored the essential importance of deep constitutional knowledge, regardless of judicial philosophy. The next day, legal commentators witnessed an unusual sight. Chief Justice Roberts arrived at his chambers early, carrying a massive stack of books on constitutional history. A court official revealed that Roberts had requested the complete works of James Madison from the Library of Congress, suggesting that he was reviewing the classic text Barrett had used so masterfully. Something more than a temporary stir. The exchange seemed to reorder the court's internal politics. 2 days later, at an open session, Roberts was seen consulting with Barrett prior to oral arguments, a move observers said was one of deference of a new sort. Loath to give up authority, as was his habit, Roberts now seemed to concede Barrett as an intellectual presence he had to reckon with. When Barrett spoke, Roberts avoided interruptions, a far cry from earlier sessions. Later in the day, during the justices' private conference, another dramatic turn of events occurred. Roberts asked Barrett to read out her opinion on a difficult jurisdictional question before he did, a rare and unprecedented display of deference to the court's junior member. Justice Kagan was reported to be surprised, as the court traditionally adheres to strict seniority when arguing legal opinions. Legal analysts soon noticed other operating tweaks. Barrett was tasked with writing the majority opinions in 2 important cases the following week, a high compliment for a junior justice. Insiders suggested that Roberts had put Barrett on these assignments to help restore collegiality and to quietly recognize Barrett's constitutional know-how. More importantly, aspects of Barrett's textualist methodology had begun to appear in draft opinions by other justices, including a partial concurrence by Justice Barrett, which had adopted portions of her analytical methodology. Media reactions followed familiar ideological lines, but a few reactions stood out. Conservative media hailed the moment as vindication. Fox News declared, "Barrett proves her critics wrong," and the National Review celebrated, "Constitutional brilliance silences doubters." One conservative pundit provided, "Barrett just demonstrated the establishment why outsiders occasionally end up being the strongest insiders." In the world of legal academia, the confrontation became foreground. The American Constitutional Society, historically liberal in its orientation, dedicated its newsletter to analyzing Barrett's approach. Yale law professors allegedly revised their syllabuses to include an offering called New Perspectives on Original Meaning, centered on Barrett's textualist methodology. Replies by liberal academics were unexpectedly charitable. Harvard Law's Alan Dershowitz gave credit on CNN to the fact that Justice Barrett's grasp of constitutional text and history is remarkable. MSNBC's lineup of liberal analysts grudgingly acknowledged that her response was pretty high in terms of intellectual vigor. Even an op-ed column by a senior progressive scholar for the New York Times conceded the fact that although Barrett's conclusions are often off-putting, her method is scholarly and rigorous. A week after the case, Justice Kagan cited Barrett's framework in oral arguments, suggesting that Barrett's emphasis on textual specificity might bring clarity. Court watchers interpreted this as a turning point, suggesting that Barrett's impact was beginning to transcend ideological divides and redefine the court's analytical mode. Inside the White House, President Biden, who previously chaired the Senate Judiciary Committee, reportedly observed the exchange and noted, "That's why confirmation matters." That amount of constitutional sophistication is what Americans deserve on their highest court. He ordered his judicial appointment staff to put forward candidates who had demonstrated skill in constitutional text analysis. The ripple effects were seen in judicial nominations. Senators began placing more emphasis on original meaning during confirmation hearings, as Democrats and Republicans both appealed to the Barrett standard. At one dramatic point, Senator Graham brandished a pocket constitution and asked the nominee to recite from memory the clause describing judicial power, a direct echo of Barrett's demonstration of familiarity. Law schools nationwide reported a surge in interest in constitutional law and originalist clinics. The Barrett-Scalia Textualist Society at Georgetown Law tripled in size. At Columbia Law School, a dean remarked, "We're seeing growing interest in originalist interpretation, even among students who don't identify with the outcomes those methods often produce." For Barrett, the day was a dramatic flip about in public perception, rising from divisive appointee to honored jurist. She was profiled in The Atlantic as an intellectual heavyweight, and Time magazine named her to its list of the 100 most influential individuals, with the article being surprisingly penned by Justice Kagan. Kagan acknowledged that Barrett's intellectual writing was transforming constitutional discourse. Book publishers bid against each other to secure Barrett's judicial memoir, bidding into the seven figures. Constitutional law texts began featuring the Barrett methodology as an independent interpretive approach. The University of Chicago Law Review published an entire issue on her jurisprudence, featuring contributors from both sides of the ideological spectrum examining her impact. Among female law students, the effect was particularly significant. Applications to Notre Dame Law School, where Barrett had taught, rose 35%. Harvard's Women's Legal Association, disagreeing with her judicial philosophy, invited Barrett to speak at their annual convention on grounds of role model status. Young women lawyers began wearing like Barrett pins in court, a badge of intellectual stature independent of politics. Chief Justice Roberts echoed Barrett's words in the next State of the Judiciary address, prioritizing textual fidelity and original principles, untypically forsaking his traditionally pragmatic approach. Legal academics interpreted this as meaning that he was conceding the intellectual center of the court had shifted towards Barrett's textualism. Roberts's behavior attested to this transformation. Without sacrificing his position as leader, he began taking originalist and textualist stances more seriously in his decisions. In a milestone separation of powers case, his majority opinion involved more historical examination than any that he had ever written. A few commentators said that Barrett had revitalized the court by guiding it toward first principles. At a judicial conference hosted by Georgetown Law, Roberts openly acknowledged that fresh perspectives challenge our established thinking, a comment widely interpreted as a veiled reference to Barrett. A constitutional scholar in attendance noted, "In 3 decades of observing the court, I've never seen a junior justice reshape its intellectual direction so quickly." The effect was instant. The court began to grant certiorari to more and more cases involving textual and originalist questions, areas where Barrett excelled. Legal briefs therefore evolved, with attorneys increasingly writing according to constitutional text and history. A top partner at a major law firm taught others, "If you're arguing before this court, you need to respond to Barrett's framework, no matter which justice you're trying to persuade." Ultimately, the Barrett-Roberts exchange transcended party politics and resulted in renewed debates regarding how to interpret the Constitution. Up the court adhere to the original meaning of the text, as Barrett advocates, or developing precedent, as Roberts generally asserted. This dialectic offers the potential to shape American law for generations to come. Scholars began referring to the Barrett Revolution. A Stanford law historian said, "Barrett hasn't just shown brilliance. She's pulled the court center of gravity towards her approach to the Constitution." Capitol Hill responded accordingly. Lawmakers reportedly started scrutinizing bill language through a Barrett-like lens, asking whether proposed text would withstand her scrutiny. One legislative aide admitted, "We're literally asking, would Justice Barrett consider this language constitutionally sound before finalizing legislation?" The most jarring shift was in the court's next milestone case. The bipartisan majority opinion wholeheartedly adopted Barrett's approach to interpretation. To many, this was the beginning of a new judiciary, not ideological but methodological. In that defining moment, Amy Coney Barrett did not merely become the court's latest addition, but also its loudest defender of constitutional text and original meaning. Her ascension demonstrated that within America's top legal institution, intellect and discipline can still overwhelm partisanship. Her win wasn't for conservatives or liberals' defeat. It was a validation of the Constitution's enduring power. Ahead, with epical choices looming on religious liberty, federalism, and executive authority, Barrett's textualist imprint is bound to leave a lasting mark. As one law professor noted, we're all living in Barrett's constitutional universe now, whether we realize it or not. The only remaining question: how will this new world shape the rights and liberties of every American? And can Roberts reclaim his sway, or has the court's gravitational center irretrievably moved? If you've enjoyed this analysis, be sure to like this video and subscribe to this channel for further in-depth analysis of the institutions that shape American life. Be sure to ring the notification bell for our new special report, The Barrett Court: How America's Newest Justice is Reshaping Constitutional Law.